Child custody after the death of a parent in Illinois. When a parent passes away, the future of their child's custody can become a major legal concern. Illinois law has specific guidelines on how custody is determined in such situations. Understanding these laws is crucial for surviving parents, family members, and anyone involved in a child's care. If one parent dies, Illinois law presumes that the surviving parent will take full custody of the child. The law assumes that a biological or adoptive parent is best suited to care for their child unless proven otherwise. However, if the surviving parent is deemed unfit due to reasons like absence, incarceration, or a criminal history involving harm to the child, a court may intervene. In cases where both parents are deceased, the last surviving parent can designate a guardian for their child in writing, such as in a will. Legal framework for child custody after a parent's death. Illinois law provides a structured approach to determining custody after a parent's death. The state follows a rebuttable presumption that the surviving parent is fit to have custody. This means the court assumes the living parent is suitable unless strong evidence proves otherwise. According to Illinois law, this presumption can be challenged if evidence suggests that the surviving parent is unable or unwilling to care for the child. A parent may also formally name a guardian in their will or another legally recognized document. This designation is valid as long as it follows legal requirements, such as being witnessed by two adults who are not the chosen guardian. However, such a designation does not override the rights of a surviving parent. If the other parent is alive and deemed fit, they will still have custody of the child, regardless of any named guardians in the deceased parent's will. Illinois courts prioritize the child's best interests when deciding on guardianship. If no legal guardian is designated, the court will appoint one based on factors such as the guardian's ability to provide care, their relationship with the child, and the child's overall welfare. WHO can obtain custody if the surviving parent is unfit. In situations where the surviving parent is absent, incarcerated, or has a criminal history that poses a danger to the child, certain relatives may seek custody. Grandparents, step-parents, or other close family members can file a petition with the court to request custody. However, they must prove that the surviving parent is unfit to care for the child. Illinois law allows family members to file for custody if the surviving parent has been absent for over a month without contact. The surviving parent is in prison. The surviving parent has a history of domestic violence, child abuse, or serious criminal offenses. While grandparents and other relatives may seek custody, they must present strong evidence that it would be in the child's best interests. However, Illinois courts are cautious about interfering with a parent's constitutional right to raise their child. The court will only grant custody to a third party if the surviving parent is proven to be unfit. If both parents are deceased, close relatives such as grandparents, aunts, uncles, or siblings may request guardianship. In such cases, the court will determine guardianship based on the child's best interests. Grandparents are often granted visitation rights unless the court finds that such visits would be harmful to the child. If a court denies visitation rights to a grandparent, it must provide a written explanation, and the grandparent has the right to appeal the decision. Obligations and support after a parent's death. When a parent dies, their existing child support obligations do not automatically disappear. If a deceased parent was paying child support, the surviving parent or guardian can seek payment from the deceased parent's estate. Illinois law allows for child support claims to be filed against an estate, but such claims must be made within 2 years of the parent's death. If a child is disabled and financially dependent, Illinois courts may order continued financial support from the deceased parent's estate beyond the age of 18. Additionally, if a parent dies before paying for a child's college education, the child has the legal right to petition for financial contribution from the deceased parent's estate. Navigating child custody issues after a parent's death can be legally complex. If you are facing custody or guardianship disputes, consulting an experienced attorney can help you understand your rights and the best course of action for your child's future. For legal assistance with child custody matters in Illinois, contact Law Office of Russell D. Knight at 773-334-6311 or visit their office at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, United States.